Welcome to the Who Moves You podcast. I'm Mike Montague. When buying or selling a home, it's always good, sound advice to have a good realtor by your side, and even better advice to have a good lawyer working on your behalf, as there can be seemingly endless numbers of complexities to each real estate transaction that are too often learned the hard way. Mark Weisleder is my guest today. Mark is a senior partner at RealEstateLawyers.ca. Mark actively shares his knowledge and advice across the country through his best-selling books and columns, and he is the go-to authority with much of our media on real estate matters and issues that both the public and realtors can meet up with over the purchase and lease or sale of a property. Welcome to Who Moves You. Thanks for your time today.
Thank you, Mike. It's a pleasure to be here.
Excellent. I'm going to get right into the questions with you because I know your time is valuable, and something we're seeing in this highly competitive market over the past year is purchasers and their realtors after being involved in one failed purchase attempt after another before they hit on that one successful one. Negotiations and the execution of real estate deals, as a result, are in some instances being rushed through, which raises the chances for due diligence being pushed aside in the interest of just trying to win or close the deal. What are the more common omissions of duty that you might be seeing in the past year from a legal perspective on the buy side in particular, even on the selling side of a transaction?
Well, because of all the bidding wars, it's really important that buyers try to protect themselves as much as possible so that they're not going to face an unwelcome surprise after the deal closes. So for condominiums, for example, you're reading about all these bidding wars. It's really important that the buyer get hold of the condominium status certificate, because this gives you all the information about the condominium, and that it is reviewed by a lawyer before they put in the offer. Sometimes there's pressure, and so buyers put in the offer without having this reviewed, and then all kinds of issues come up after closing. So with me, as an example, I do these reviews for buyers who may go into a bidding war, and unlike many firms, I don't charge for that as long as they agree to use me for the closing. Even if they lose the bidding war, I don't charge them. That's how I build relationships with people. And so, and there are others that will charge. Now, when it comes to a detached home, it's all about the home inspection. And that's some sellers will have a home inspection report done before they put the house up for sale. It's not as good as a buyer having their own home inspection, but it reduces a little bit the risk when at least you have the chance to review a home inspection before you make your purchase firm. And so those are some ways that buyers can protect themselves from finding out unwelcome surprises after closing.
And we have seen increasing numbers of deals where offers do not include financing clauses, or in some case, any protective clauses for the buyer. And they're doing this as a ploy, more or less, to beat out competing offers. Sadly, some realtors are telling their clients that this is the only way their offer is going to have a chance of being accepted over competing offers. And with that, we're seeing an increase of firm offers that can't close, either because the buyer later learns they're not qualified for the financing, or in some instances, the sale price of the home is higher than the appraised value that the lender has determined, and the buyer doesn't have the funds to make up the difference. Often this leaves parties looking to be compensated for damages of any number of costs that can arise. Is there ever an acceptable circumstance where a realtor should allow their buyer client to submit an offer without protective clauses?
I understand the pressure when people do. And you have no idea how many buyers call me the next day after they're successful with a winning bid with no conditions, and they say, we don't want to pay the deposit. Because typically when you sign a contract, you have 24 hours to pay the deposit. So many buyers mistakenly think that, well, I signed the contract, but as long as I don't pay the deposit, I can cancel. Well, it doesn't work that way. You know, by not paying the deposit, you can be still sued as if you paid the deposit and refused to close. And this is the problem when people are putting in offers, getting caught up in the excitement and not having conditions. And then, of course, they will blame the realtor. saying that you push them on. Now, there is a form for realtors called 127. It's an AREA form. And I highly recommend realtors use this whenever a client is telling them, make the offer without a condition, because at least then there's proof that the realtor did warn the client buyer not to do this, but they made the decision to do it. But you are correct. There are many ways a deal can fall apart, even if a buyer is pre-approved. Just
Yes.
because you're pre-approved doesn't mean you're getting the money, because as
No.
you correctly said, an appraisal still has to be done. And if they feel you paid too much, you're not going to get the mortgage you think you need, and you're not going to be able to close.
Yeah, exactly. And in that scenario, in other scenarios, the first action many realtors take when a deal does fail to close is reimbursing the deposit, which requires a mutual release signed by both parties to the transaction and by their representatives. What those on either side of the transaction, including realtors, and I've been caught up in this, in some instances, they fail to realize that in signing a mutual release, they're also releasing one another from liability claims or further legal actions against the other party. What are your thoughts on forfeiting protective clauses to strengthen the appearance of the offer? And when they do sign a mutual, should they sign that mutual release if the deal does fail, or should they hold back?
When you say who should sign, are you asking me if a realtor should sign that mutual release?
Well, there's the two parties involved need to sign off on the mutual release. And within that mutual release of the AREA form, there is the provisions in there that of waiving all liabilities and further legal actions against other parties. So once that's signed and the deposit's returned, if somebody wants to take further legal action, cover damages, and it's usually the buyer in that situation, or not always the buyer, it can be the seller, it can be either party, depending on who defaults.
I'm a big believer that to settle your differences and sign a mutual release is always the best financial decision you can make. What people don't understand is when you sue somebody, the only winners are lawyers. Nobody else wins. Nobody understands the costs of a legal fight. And lawyers ask for their money up front, and there's no guarantee you're ever going to get a win, or even if you win, your costs back. And so to me, if you can settle your differences and sign a mutual release, it doesn't matter if you can no longer sue somebody. The result is still better. Any settlement is better than a lawsuit. So I encourage people, please try to negotiate a settlement, because otherwise it's a nightmare. And I've seen people involved in 5 years of lawsuits with no end in sight, hundreds of thousands of legal fees, and all could have been avoided by just negotiating a release at the beginning. So look, bad things happen, but you're better off once it happens finding a settlement that works.
Good advice, for sure. And would you say there are any circumstances that could be specifically considered a result of COVID-19 that would override a signed agreement of purchase and sale should one party or the other want to walk away or have to walk away from a deal that is firm?
Unfortunately, you cannot cancel a real estate deal because of COVID. People thought this was going to be an issue a year ago, and I wrote a year ago it wasn't going to be an issue. Sometimes you can understand if a deal has to be delayed. If somebody's in quarantine, okay, we'll delay a deal for a short period of time, but it will never rise to the level of canceling a deal. So as an example, and there's nothing in the contract that would allow it. So as you can imagine, there's a lot of new construction going on all over Ontario. And because of COVID, projects had to be delayed because they couldn't work. Well, builder contracts say that if something like that happens and it's an unavoidable delay, then the project or the home can be delayed and the buyer has to close. That does not apply on a regular resale home. It's unfortunate, but when you think about it, think back a few years ago when the government brought in the speculation tax, 15%. The market fell like 15, 20% overnight. And so people said, well, I can't sell my house. I bought a house. I can't sell my house because the market changed. That's not an excuse. So unfortunately, COVID, you lost your job, the appraisal came out bad. This was not and is not a defense to breaking a contract. You've got to try to find some kind of a settlement that will work
Yeah.
for you.
Get both parties on the same
Yeah.
pages. Yeah. So, and one related COVID related frustration that I'm hearing is from condo owners who are frustrated at having to continue paying their monthly fees at the same rate when the facilities and amenities like the pool, the fitness room, the party room, they're all closed. They've been closed for a year. If they wanted to challenge those fees that they are having to pay, do they have a legitimate claim on that?
Absolutely not. You have to understand that the duty of a board is to make sure that they're collecting enough money to pay for services. That's
Mm-hmm.
it. That's at the bottom or the bottom line of every condominium. So,
Yeah.
yes, they've had to shut down some facilities for
Mm-hmm.
use by people, but also some revenue sources have dried up. Nobody's renting the party room anymore. There's
Mm-hmm.
no more visitors parking fees. So they're losing revenue at the same time. And they have to spend extra money in order to keep everybody safe with this, all this stuff you have to do to spread everyone out in rules and everything else. So you can't just look at one aspect of it and say, well, I'm not getting the use of this facility, so I should pay less.
Right.
Every condominium has to work as a business. You take enough money in to provide the service.
Yeah.
So it's
And there are
not
still there's ongoing maintenance costs involved as well, I would guess too. So the province says remove the landlord's right to evict for non-payment during the pandemic. I believe this protection applies both to residential and commercial tenant. Does this absolve the tenant altogether from having to pay any back rent owing, or is it simply a delay mechanism? Because there's some confusion out there with some people, I think.
I think for residential, this bothers most people right now because as a result of the pandemic, you can still take the tenant to the board. You can collect an order for non-payment of rent. But the
Mm,
final step, which is a sheriff coming and forcibly evicting you, that
mhm.
was shut down during the pandemic. Now,
Okay.
it will slowly open up. So as Ontario opens up, you will be able to get the sheriff to go to do this. And all the money that tenants were holding back and not paying, it's going to be payable. And
Right.
this is going to affect their credit. They may have their wages garnished. It's just for the last 6 months, everything's been delayed. It's been very hard to get a hearing in front of the board. And, and then you have the final aspect of the sheriff not being able to go and do an eviction. So it sort of caused some tenants to think, oh, I'll never have to pay the rent. Well, it doesn't work that way. They will have to pay eventually. And
Hmm.
the hope is that, at least in most cases I've seen, landlords and tenants are trying to work it out. Maybe they
Yes.
reduce the rent a little bit for a little bit of time, and then it goes back up to the rent. So in most cases, you're not seeing, in I believe, people try to take advantage.
Can a privately conducted purchase and sale of a home without the use of a licensed realtor, will that leave more work and potentially more expense for the lawyers involved in that real estate transaction?
Well, I find that in all the deals where I've had to get involved, where people do a deal themselves, it's never simple. Number one, people think, oh, I'll make a deal and then I'll go get a mortgage. Most lenders don't trust the price in a private deal, which means they're going to have a different appraiser go in to make sure that the buyer paid a fair price before they approve anything. So right away, there can be, holdups. I find that when buyers and sellers do it themselves, they make mistakes. The agreement is probably void because it's not accepted properly. So what does that mean? It means one of the parties could get out of the deal almost at
Mm-hmm.
any time because it was not put together properly in the first place. And then when it comes to the price, I always look at the net price. People think they're saving all this money. in real estate commission, but they have no idea whether they're getting a fair price for their property. And so, just as a lawyer who has to close the deal, I have found that they're, in most cases, put together terribly
Mm-hmm.
and probably void half the time. And it's just not as simple getting
Yeah.
it closed.
The underlying advice within there speaks for itself. The Ontario Real Estate Association, along with the Trust in Real Estate Services Act, which was up until recently RECO, arguably provides the Ontario consumer with the highest level of protections and professionalism in the country and maybe even on the continent with regards to the transaction of real estate. Even so, it's a journey and it's not a destination. Given your experience interactions with Ontario realtors and our industry, are there changes or areas of the business that you would like to see strengthened or improved?
Well, I believe that people who are working in the business full time and go to continuing education courses and are always learning, those agents continue to do very well. And they protect their clients and they protect the public in everything they do. I find that if some people are doing it on a part-time basis, they have another job and they're selling part-time,
Mm-hmm.
that's when problems happen because they're not properly prepared.
Yeah.
And they don't know how to properly protect buyers and sellers when they sign agreements. And legislation was tougher. They upped the penalties. So,
Mm-hmm.
you do something wrong, it's a much higher penalty. And if complaints are made against you, it may not be so easy for you to renew your license in the future. So
Yeah.
I think from the government side, they're doing what they can to, make sure that people follow all the ethical rules. It just, in my experience, as I said, the agents who are busy now, they've been busy for the last year. They just found a way on practicing safely during the pandemic and keeping the economy moving. These are the same ones that, still find the time to always increase their knowledge. And that's why, in general, the public is served better.
Well, I appreciate your time today. We're going to keep it tight, and hopefully, we can have you back at a later time. And I want to give you a chance. I know you've written a lot of stuff. Is there anything anywhere you would like to direct people with regards to your books? Anything that might be helpful for anybody
If
who
any,
has further interest here?
thank you. Look, people have lots of questions when it comes to real estate matters.
Yeah.
And I always invite people to send me an email to Mark, MARK, at
Mm-hmm.
RealEstateLawyers.ca. And I can tell them all about our rates if you're thinking of
Yeah.
buying or selling, or if you're interested in any one of my publications. I've written a guide for landlords, buyers, sellers. I'm happy to discuss that with you as well, how
Yeah.
you can order it. But thank you for that.
Yeah, for sure. And one more thing, I don't think all law firms have adapted their processes and businesses to COVID as well as you guys have.
Yeah,
Tell us a little bit about the conveniences you've put in there to make your business accessible to those who are buying or selling needing a realtor right now.
thank you. Thank you. We started things before the pandemic
Yeah.
and we didn't realize just how important it would be. So right now, we can do every part of a real estate deal without ever seeing a client.
Mm-hmm.
So from the time if you were a seller, we would get the agreement, we would do all the paperwork, we would sign the closing papers with you in a Zoom meeting using DocuSign, just like this. And then after closing, we would deposit the money digitally with an
Mm-hmm.
electronic funds transfer. So it would be in your bank account the day after closing without a hold from the bank. There's no certified check, nothing. Now, let's say you were buying from me. It would be the same thing. And we would sign all the paperwork this way, so completely safe. But our firm, to my knowledge, is the only firm in the province that is a bill payment at the bank. So the same way people watching your show pay a hydro bill online, they can actually pay the down payment to my law firm from their computer online. They don't have to line up at a bank with a mask, get a bank draft, and drive it over to a lawyer's office. It's not even necessary. And we have an account at every major bank. And so we make it simple for the buyer to pay us. We make it simple for us to pay the seller. We pay all the real estate brokerages the same way with an EFT. And we pay money between law firms, everything digitally. So we can do everything from our laptops. Nobody has to go to the bank. And so this permits us to close a deal completely safely. And then the final piece was always the keys. When we started, even before the pandemic, we would give lock boxes to our sellers. So instead of having to pick up keys and then deliver them to a buyer lawyer, we would say, just send the buyer to the house after closing and let them in with a code. And we just left the keys at the property, because that way you didn't have to deal with couriers in the snow getting delayed, and you just closed the deal. So now one of the positive things with COVID is that more people are cooperating to make sure the keys are there. So it's a safe exchange at closing. So we have tried to find every way to make a purchase and sale happen completely safely and much more conveniently for buyers and sellers. So we're very proud of it. And as a result, that's one of the reasons we've been busy, because we make it easy for buyers and sellers to close a deal.
Well, I do appreciate that. And I expect you will continue to be busy for the foreseeable future here, the way things are going. Thank you very much, Mark Weisleder, senior partner at RealEstateLawyers.ca. Visit them and they'll take care of everything you need with regards to your legal. Thanks again. And we'll talk to you again soon.
Thank you. Thank you, Mike.